Why intellectual property is important? Yes, this slide is here.
Okay. I wanted to actually share a link.
Your voice is audible, sir. Absolute no problem.
No problem, but I wanted to share this link.
Okay, sir. For any kind of
So should I put this link whenever I need? I will give it to you. I will
yes, sir.
copy the link and share. Let me see why it is not open actually. Okay. I'm not able to click here on this link. What is the problem? I don't know.
I think that's on a YouTube link, sir.
Yeah.
Yeah, that's actually.
I have some two videos actually I want to show you about
Yeah,
these
that.
sites actually. So that's why I wanted to share this. So I will share this link, then you can upload over there. That may be possible.
Uh, Dilip, sir, who is the host, sir? Who is managing the connection? I think.
Sir, the office home is there. He'll do it. I'll tell him to do it.
So I will share this link on chat. Okay. So
I
then
think
That's fine, sir.
1 minute, sir. Home line down, sir. Home.
so you can then you click on it so it can be visible. When this slide comes, and then I will share.
Home. ହୋମ୍ ଟିକେ ଶୁଣ ସାର୍ କଣ କହୁଛନ୍ତି କରଦମ ସାର୍ କହୁଛନ୍ତି କଣ ଟିକେ ଶୁଣ ତାକୁ ଟିକେ ଦରକାର ଟିକେ ଇଏଟା ଚଲେଇବା ପାଇଁ ତାଙ୍କର ପିପିଟି ଟା କେମିତି ଚାଲିବ ଟିକେ ଶୁଣ ସାର୍ ହଁ ସାର୍ ଆପଣ କୁହନ୍ତୁ ସାର୍ ୟୁ ଟେଲ୍ ସାର୍ ୱିଲ୍ ଡୁ ଇଟ୍
Okay.
ଡକ୍ଟର କରଦମ ସାର୍ ଆପଣ କୁହନ୍ତୁ ଆମ that person who listening is do it.
Okay. No problem. When this slide comes, I will share.
शांति हो ଟିକେ ମାଇକ୍ରୋଫୋନ ଯୋଉମାନେ ୟୁଜ କରାଉନି କାଇଣ୍ଡଲି ଅଫ୍ participants those who are not speaking now kindly put your microphone ସୁସ୍ମିତା ମ୍ୟାଡାମ ଆପଣ ମାଇକ୍ ଟା ଅଫ୍ କରନ୍ତୁ ହଉ ଆରେ ହଜାନ ମାଇକ୍ ଅନ୍ କରି କଥା ହଉଛନ୍ତି କହିଲେ ଶୁଣୁନାହାନ୍ତି ତୁମର ମତେ କରନ୍ତୁ ତୁମେ କରିଦିଅ ମତେ ଖରାପ ପରେ
ବେହେରା ସାର୍ ନମସ୍କାର।
ସାର୍ ନମସ୍କାର ନମସ୍କାର।
ସାର୍
Where are
କୋଉଠି
you,
ଅଛନ୍ତି?
sir?
ଭୁବନେଶ୍ୱର ନା ଦିଲ୍ଲୀରେ?
ସାର୍ ଦିଲ୍ଲୀରେ ଅଛି।
ସାର୍ ସାର୍
ଆଉ ଇଏ ଆମର ସାର୍ ଆସିଲେଣି ନା?
ହଁ ହଁ ସାର୍ ଅଛନ୍ତି। ଆମେ କଥା ହଉଥିଲୁ କରଦମ ସାର୍ ଆଉ ଆମେ କଥା ହଉଥିଲୁ। ଆମେ we are waiting for the participants.
ହଁ ନାଇଁ ନାଇଁ ପାର୍ଟିସିପେଣ୍ଟ ଅଲରେଡି ଜଏନ୍ ଗୁଡ୍
ହଁ
ନମ୍ବର।
ଜଲେଣି already
ସାର୍
including
ୱେଲକମ୍
us 16.
ଡକ୍ଟର ସାର୍।
Thank you, Vera Saab. Thank you. How are you?
ସାର୍ ଫାଇନ୍ ଫାଇନ୍।
Very nice.
ଥ୍ୟାଙ୍କ୍ସ ସାର୍ ଫର୍ ୟୋର ଗ୍ରେଟ୍ ସପୋର୍ଟ ଟୁଡେ ଫର୍ ଓଡ଼ିଆ ଏଣ୍ଟରପ୍ରେନ୍ୟୁର।
My pleasure.
ସାର୍ ସାର୍ so our Satpathy sir is there, one of the GM of Indian Bank, and Mr. Kaur, Dr. Kaur is there.
Hmm.
Sir.
No, it's very nice actually organizing this kind of program. I think it is very, very important actually.
No, no, sir. Thanks for your all full support, sir.
Today, there is a launch of a book by Justice Pratibha Singh. So I had a invitation, but the timing is same, so I couldn't go. He invited me for a program.
Sir, along with others, I am also there. Avinash Pawar.
ହଁ ମୋତେ ଟିକେ ପଠେଇ ଦିଅ, ତାଙ୍କୁ ଟିକେ ପଠେଇ ଦିଅ ତାଙ୍କ ନମ୍ବରରେ। ଆଉ ତମେ 10ଟା ବେଳକୁ ଆସିବ, ଆଉ ନମ୍ବରଟା ସେଭ୍ କରି ରଖ। ହଁ। Mm. Dilip sir,
Sir, we'll start by
sir,
after 10 minutes. 4:45 exactly.
you start. You can
Okay.
start now.
Okay.
You can start. Welcome our speakers, and you can start that. Please, please.
Respected Dr. Krishnan S. Kadam sir, he is the former senior joint controller of patent and designs and former head patent office Delhi. Today he is speaking on significance of patents in innovation and intellectual property protection. And to assist him or to moderate the thing, Sri Dr. Sachikant Kar, Head of Marketing Consultancy Quality MSME Services Division of this Central Tool Room and Training Center, Bhubaneswar. Both are having vast experience in this line, and this patent and this intellectual property protection is a major issue the entrepreneurs are facing today. So those who are attending this and those also who will be sent, this program is sent live also, they can watch it. So now I give the stage to Dr. Sachikant Kar sir. Kindly continue with your presentation as well as the role as a moderator. And Sir Kadam, thank you once again, sir, for joining us and giving a valuable time. Please, sir, go ahead, sir. I am logging out.
Okay, thank you. So, namaskar. With due respect to today's chief speaker, chief guest, and the knowledge veteran with us, Dr. Kishan S. Kadam, sir. Namaskar. We welcome you to this today's webinar, sir. And with due respect to OCF chairman, Mr. Behera, and to Mr. Dilip Prasad Satpathy, and all esteemed members, those who have taken the initiative to conduct such kind of a most valuable awareness program in the field of the intellectual property right protection for the MSMEs, researchers, and the professionals. Those who are, due to lack of awareness, they face many challenges and the problems in their field. They suffer because of due to the lack of awareness in IP protection. So I welcome and I congratulate you, OCF, for this auspicious occasion organizing in the interest of the people in Odisha. Odisha, as we know, as per my experience is concerned, many of the entrepreneurs and intellectual people, they are really lack of IP protection knowledge and awareness. So this kind of programs is very much useful. Sir, with a little introduction, as Dr. Satpathy has introduced me, I belong to Central Tool Room and Training Center, Bhubaneswar. It is one of the leading technology center in the country under the Ministry of MSME, Government of India. Basically, there are three activities: training, production, and consultancy services. Training, we provide various skill development programs, long-term, short-term, medium training programs, right from the school dropout till post-graduation certification programs. Also support to the research scholars in the different, carrying out different type of experiments, validating the data and support their guidance, etc. And we do conduct various overseas training programs in other countries, other developing countries, in collaboration with the Ministry of External Affairs, for creating high-tech infrastructure facility, designing of the skill development programs, and executing in those countries. Apart from that, we are also having the state-of-the-art facility for production center, where we are designing manufacturing precision tools, components, assemblies, and to take a note of this, sir, for your information, sir, to the success of the Chandrayaan 3, we have supplied more than 56,000 components from CTTC Bhubaneswar. We are the technical partner with the Indian Space Research Organization for all Aditya L1 mission, Gagan-1 mission, and Mars mission, all space mission programs. Apart from that, sir, the LCA, Light Combat Tejas aircraft, which has been inducted to the Indian Air Force, is designed indigenously by Indian scientists in collaboration with others. So we are also working the TDA project, Technology Development Fund project, designing, manufacturing, assembling, testing. We are supplying various components and hardwares for the LCA, LRUs, and the different kind of items. And we are having a consultancy service division where we are dedicated to provide various kinds of technical and management consultant services to the MSMEs, startups, and others. In addition to that, of our interests, as you are aware, there are 10 technology innovation support centers in India. Out of this, under the WIPO, and out of 10, one is at CTTC Bhubaneswar. We support, we provide our support services both in the technology development, IP facilitation services to the different startups, MSMEs, and others. Sir, we have already executed 3 GI certification at Kandhamal Haldi, Odisha Raja Talgut, and many other IP facility services provide, like patent, designing, trademark, copyright, GI, and market competitive analysis, FTO analysis, like IP portfolio management. Those kind of services they provide. It is immensely, many people are benefited, and we are trying our best to develop one IP ecosystem, innovation and ecosystem in the state. Odisha is usually being considered as innovation wise and technology development as backward, but we have created an ecosystem under the all DPIIT and Department of Science and Technology, Ministry of MSME, Government of India. All these organizations are working in a convergence mode, how to create an innovation and IP ecosystem in the state. This is today's initiative and your august presence and the knowledge. You are sir encyclopedia of the knowledge in the field of the IP. I have gone through profile naturally, sir. There are a lot of things to learn from you, and it will be great inspiration for all these participants here to know, to get themselves educated and to know how to protect their IPs. Before we start, I would like to have the pleasure of introducing Dr. Krishnan S. Kardam sir's a big background. Sir was the former senior joint controller of the patents and designs and former head of the patent office at Delhi. He has worked in the Indian Patent Office for the last 37 years and held various positions. He has superannuated in the 31st July 2019 from the post of Senior Joint Controller of the Patents and Designs. He headed the Delhi Patent Office and the Indian ISA IPA. He was selected as a technical member of the Intellectual Property Appellate Board, IPAB, in the year 2016, but did not join due to some of the personal reasons. Sir did his post-graduation in organic chemistry. He has also studied law from Delhi University and hold master degree in law. He has done PhD in the intellectual property law, also from the Delhi University. Sir is associated with various universities, government department and research organizations as a member to their IPR advisory committees for formulating their IPR policies. He is also providing consultancy, mentoring services to various startups and pharmaceutical companies. He has published several papers in various journals on the topic related to the intellectual property. When India joined WTO and TRIPS, he had actively participated in the process of amendments to the Patents Act 1970 for the revision of in the patents rules. He was also one of the members of the task force constituted for the traditional knowledge digital library TKDL for protecting Indian traditional knowledge. Sir had conducted 6-month research study in Japan about the utility model and its economic and technological significance to India. Under the WIPO sponsored program, Sir had the privilege to visit patent offices such as the USPTO, EPO, JPO, SIPO, GPTO, MyIPO, Indonesian Patent Office, etc. to understand their IPR system and also delivered lectures on their training programs. He has participated and delivered lectures in several international, national seminars, workshops, and symposia organized in the field of the intellectual property rights. Sir had been actively involved in the participation of the manual of patent office practice and a procedure like MPOP preparation, patent office practice, examination guidelines for different inventions relating to the biotechnology, traditional knowledge, chemicals, pharmaceutical, computer-related inventions, etc. He has also represented India on many occasions in WIPO in respect of Standing Committee on Patent Law, PCT Working Group, meetings of international authorities, WIPO Intergovernmental Committee in Intellectual Property and Genetic Resources, Traditional Knowledge, etc. With this profound background and vast knowledge, experience and expertise, it is a great privilege and honor, sir, to welcome you. And we are really privileged and blessed to have the opportunity to learn something from you. I request, sir, I hand over the now platform to you, sir. Kindly go ahead for your presentation. Thank you, sir. Welcome you, sir.
Thank you, Dr. Karth. And I'm privileged to be part of this program which you are organizing. And I also thank for the invitation. I also thank Mr. Mehra Saab that he got me connected to this very, very important platform and organization. I think it's very privilege to me. And as I heard, I think your central tool center Bhubaneswar, I think is really working wonderfully. And as you mentioned that there has been a lot of contribution to Chandrayaan mission of Government of India. I'm very proud of your center, and not only me, but I think whole India is proud of your work, because this is this was a prestigious mission. So, because you are well connected to the MSME, and this is an area I think very relevant for the MSME as well, because MSME is contributing, to the Indian economy to the great extent in terms of revenue, economy, in terms of employment, in terms of economic growth and industry growth. So it is very important, and the government of India has also taken several initiatives. I think somebody has to mute. Government of India has taken several initiatives to promote intellectual property protection of MSME. So earlier, when before 2016 or 17, there was no separate, relaxation or fee concession for MSME. That when we propose this, that MSME one sector where we need to promote them, and I also studied the utility model. Why it is important for MSME. So my research is also uploaded. You can find this research on Google and in my office website also, IP India website. So the utility model was one which I thought that, because MSME sector, the product, sometimes you are not able to invent new product, like that patent. When we talk, everyone talks about patent, innovation and all, but they really don't know that there is another area which also part of the innovation and intellectual property. One is the utility model, where the product remains same, but if you add certain features which are useful, small change can make a product more useful. So, but this, unfortunately, this law is not there in India. But despite the fact that we others, beside patent, where you need lot of research to get the patent, because it has the standards of getting patents are slightly higher, but we also have a design. So what our MSME sector is doing, maybe sometimes they are improving the design, or they are changing the outer shape of the product, and they are coming up with the certain small changes. So we don't do, our MSME has to understand that beside patent, there are other form of intellectual property also which may be very useful for them to protect. So in this presentation, I will try that what are the various advantage or the government scheme which needs to be utilized by MSME sector, and in general, and startup companies, because today we have a lot of startup, and startup India program is there. So government is promoting startup company as well. So in this presentation, there are a lot of information regarding how to promote and protect the intellectual property of startup and MSME. So then I will start now. So as you all know, the intellectual property is nothing but anything which is created by application of human intellect. So suppose you write, there is a thought process in your mind or idea that I need to write a poem, or there is a poem coming out from your thinking. The poem itself is an intellectual property. Suppose you are thinking to write a song. The song is also an intellectual property. The clothes we are wearing, sometimes we have a different kind of design of the clothes. Sometimes So that is also intellectual property. So I say that anything which you create, which you create is intellectual property by applying your human mind. Just a minute, just a minute. Just can I? So the point is where anything which is created by human intellect, which can be used in a commerce, I mean, can be traded, is an intellectual property. So earlier, you people used to think only about the property means physical property, tangible property, like land, building, chair, other things, no? Table, movable, immovable. But earlier, never thought of intangible property. That is intellectual property. So our forefathers, they used to distribute the information free of cost. That information, the knowledge has become part of our economy that generates revenue. So the intellectual property are of two types. One is industrial property, that means anything which can be made or used or by the industry. That means any patent, I mean for any product or new innovation can be made by industry, or any process can be used in any industry. So they are they are known as industrial property. But there are another kind of property, copyright, uh, which is a literary work, or that is a publication store. So there is no need of any industry to produce that. So these broadly the intellectual property is divided in two parts. Then after once you create a property, you need to protect it by certain form of you know certain forms, and once it is protected, then you get the right over that particular property. So once it is protected through patents, or through trademarks, or through design or copyright, or through any other form, then it then you the creator gets a right, and that right is intellectual property rights. The owner get that right. Why the system is there? Why even patent should be granted? Why it is copyright should be protected? Because based on the principle of quid pro quo. Means so it balances the right of the society, rights of the public, rights of the owner or creator. So there is a balance between the balance, both the, I mean society as well as the creator get the benefit out of this intellectual property. Why intellectual property is important for industry or for any startup or any other creator? Because it enhances the image of the enterprise. Suppose you have patent, or you have a trademark, or you have copyright, then you are in a competitive age compared to others, those who are not protected. It generates revenue since you can license it, you can sell it, or you can or start your own industry. So it generates revenue. So it is very important to protect your intellectual property, and you can create your own startup uh, to deliver or to produce the product, or to implement the ideas. You can become entrepreneurs. In foreign countries, the professors which are teaching in the university, uh, and during their research, they come up with a new idea, and after those ideas are protected, they become a startup or they become entrepreneurs. Like any other property, it can be leased out, it can be licensed, it can be mortgaged, it can be assigned, it can be used as a collateral, it can be auctioned, it can be gifted. Anything you can do it. So it is just like any other property. But if you don't protect it, you can't do, anyone can copy it. So, so you have a right, but you protect it, you prevent others from using it without your permission. So this protect you from copying, imitation, or infringement. So the intellectual property is evidence the life. So just an example for you to just make you understand what is the difference between patent, design, trademark, and copyright. So this an example you will be able to understand the basic difference between all. Sometimes we say that rice is patented. Sometimes you heard in the news that our neem is patented. Sometimes we say that our haldi is patented. But what is it? We really don't know what kind of things have been patented. So this is an example of the pressure cooker, So these pressure cookers are of different shape. You must have observed that all three are different, are of different shape. So that means there is a innovation in their shape. Shape is important. So this is a matter to be protected through design because it is reflecting the new innovative idea in the shape. It is a matter of design. That means aesthetic part of aesthetic creation of a known product, or maybe a new product, or maybe a known product. You can give some aestheticity and you can get a design for it, new aesthetic creative or outer shape. When this is a pressure cooker, when we talk about understand about the patent, what is in patent? What can be patented in it? So like this is a pressure cooker and there is a lid over it, lid. Suppose you use this pressure, this part and a lid, then there may be a pressure inside, inside the pressure cooker, or maybe due to pressure the vapors are coming out of it. Then somebody use the that rubber, rubber. So then this leaking of vapors is prevented. So that is a invention. That is a patent. So somebody inventing the rubber to put on the lid and to avoid leaking of vapors or steam. So that is a patent matter. That means it is a technical matter. So if we are solving the technical problem, and similarly when the pressure goes up, so there are chances of bursting of this particular pressure cooker. And so somebody has invented a pressure valve. So this pressure valve is put in the lid, and if the pressure increases, this lid comes out, this valve comes out, which prevents the bursting of pressure cooker. So this kind of new ideas, they are protected through a patent. And then if you want to sell this cooker in the name of let's say Hawkins, so or let's say some other name, so the name of by name you are selling in the market, or by logo or any if you put it, that will be protected by a trademark. And you must have seen when you open the box, or when you buy a new pressure cooker, you open the box, then there is a manual, some guidelines, some booklet. Then there you find certain instruction how to use it, what sort of precaution one should take. And so that kind of instruction contained in the booklet or manual, they are protected under copyright. So there are one product, but there are many intellectual property in it, right? One product can be protected by different kind of intellectual property. We just not think of patent. You think others intellectual property also. They are very, very important. So the intellectual property rights may be patents which are exclusive right for inventor for his invention. That gives you a right to make, use, offering for sale, anything, any which is protected, or maybe a process. And the one is design, which I talked about. I showed you the example that relate only for the features of shape, configuration, pattern, ornamental, composition of colors, lines, or combination thereof applied to the article. So this is the designs is another kind of intellectual property where the product, the outer shape, features, or colors combination you can use as a new aesthetic product. Then trademark may be a visual symbol, word, signature, name, device, logo, label, anything, a combination thereof, or maybe a sound, or maybe a slogan. So you can protect through trademark. The another intellectual property is the geographical indication. Geographical indication, you have already mentioned that you have got 3 GI protected under your central tool room, and I think you are aware, but for other participants they should know that any product which may be a natural, or maybe a agriculture product, or maybe handicraft, or maybe man-made, which has some indication, or originating from the area or region that or locality in that region with certain quality or reputation, those products can be protected through GI. So there is one difference between the GI and other kind of intellectual property is that any single individual, or maybe jointly, or independently, or company can own, they can protect in their name patent, trademark, design, copyright, but not GI. GI is only protectable by the people, group of people, association, organization, which are uh, representing the interest of those people who are promoting it, or those who are producing it. So the GI is not individuals' right, but the group of people representing those areas where those products are manufactured, or created, or grown actually. So this is GI. And the copyright, as I said, is relating to literary, dramatic, musical, artistic, or cinematography and broadcasting right, so which can be protected by copyright. Patent, as I said, it is a intellectual, again, a statutory right granted for 20 years or to the inventor, or is assignee, or the company, even, or statutory, or maybe non-statutory organizations, they can get patent. Basically, its object is to prevent others from making it or producing it without the consent of the owner. This patent is granted for new process or a product which is novel, inventive, and capable of industrial application. Novel means it should not be known before. It should not be part of the state of the art. So that is novel. So we follow global novelty concept. That means it's not be known, or it's not be published, it's not even used anywhere in the world. So the patent office maintains the database, global database, where they can search. Inventive means it should not be obvious to a person skilled in the art. Just if any person in a tool room can make small changes, then but obvious changes, then that means it is obvious. But if a person in a tool room or industry make some such changes which the previous inventor could not have thought of, so it is not obvious. So that can be patented, and it should be industrial capable, industrially applicable. The invention should be used or maybe made in the industry. So if somebody says that I have invented a medicine for curing the cancer, but suppose it is used or it may be it will be provided only on the day of full moon. Oh, okay, let's suppose somebody says so. That means the product he is talking about cannot be patented because it is not it is not made in the industry. Because if you are producing in a condition of full moon, no industry can manufacture that kind of thing, you know. So that kind of thing cannot be patented. Why patent is important? Because it provides you exclusive right to prevent others. You get the legal protection from duplication or copying. As I said, that you get the income from licensing assignment, and once you get the money, you get motivation to do further R&D or quality control, other things. And suppose you are working on already known patented invention, you are improving it. So if you have added new feature of some known patented technology, that you can bargain for cross licensing. That like there's a mobile phone you have in the market, and somebody has changed its interface, make more useful, then either he can sell the technology to the mobile manufacturer, or if you want to have your own company, you want to start a mobile manufacturing, then with your idea you can ask for the license in the and bargaining that I will give you my idea free of cost, you give me the license. So you can use as a one of the tools for cross licensing. So once you get patent, then it reduces the risk of infringement. And the patent is very important source of scientific and technical literature. Every patent is published. Every patent is published. There are 3 million patents application filed every year, around 3 million patents. So this is the biggest source of information. There is no other technical journal, you know, or publication which is equivalent to patent publication. And it avoids duplication of research. Suppose you are doing some research, but later on you found that this research is already published in so and so patent. Then your time and money spent can be saved if you conduct a search before you take up any research work or project or to do some research. It is important to conduct a search on the patent database so that you can avoid your time, you can save your money also. And it is you can identify the very emerging technologies. Once you nowadays we talk about AI, generative AI, and all, and through patent search you can find out how much progress AI has made in India, not only in India but abroad. How many patents are there? How they are used? So a lot of information is there in patent, and you get the opportunities for establishing, creating startups and providing jobs to the people. So once you have patent, you are not afraid from your competitors. Basically, you suppose you have a patented technology, your competitors cannot copy it, your product. Once you bring the patented technology in the market, the competitors will not touch your area, and they will be forced to do further research to avoid your kind of product. So this is a system which recognize the patent, provides you the rewards if it is commercially used, and serves a incentive for the inventors to do further research. So how the patenting process from idea generation and all, just a small, it's not too complicated, it's very simple. Once you generate the idea, and by solving some important problem which you face day by day, and then you verify that idea whether is there any prior patent on it or not. So there are certain prior art database which are available free of cost. One is the Google Patents database, and you just write Google Patents, you'll find, you can search. There's a WIPO patent scope. There's another free of cost database, and then European Patent Office database is there. They are all free. Or India Patent Office website is there. There you can search any patents similar to your invention. So you compare whether this already known or my product, my idea is new. And then if your idea is new, then you can testify, make a prototype model or some process, verify it. Or nowadays, there are a lot of universities, they are providing this kind of facility, to test your idea and all. And once you do that, once the idea comes to your mind, and you have, since the patent, if you you inform anyone about your idea, so you will lose the novelty. So before you tell your idea to other people, you file a provisional application. So there is a provisional application. Then within 12 months you can file a complete specification. So 12 months time is divided to you, and then file a request for examination within 48 months. Now we have Indian Patent Office has published change in the rule. Now they are going to change from 48 days from 48 months to 32 months. 32 months they are going to do it. And then controller, after filing the request, this application is examined, and if there is objection, you reply those objection within 6 months. If there is no objection, the patent will be granted. So this is a process for granting patent. And for MSME, there is a 80% fee discount, number one. So any MSME or startup, they get, government has reduced their filing fees to 80%. So they have to pay only 20%. So this is one advantage for MSME to promote innovation of MSME and startup. And for startup, there is a facilitator appointed by the government. There is a list of facilitator, or IP Mitra, we can now revisedly call IP Mitra, who will help you in filing, in prosecuting of your patent application, trademark application, or design application. And the fee of those IP Mitra or IP facilitator will be paid by the government, the patent office. The applicant need not to pay any fees except the government filing fees. So the attorney fees, the IP Mitra fee will be paid by the government. So these, if you are interested in filing the foreign application or international application, then after filing the provisional, you file complete, and at this point of time you can think of filing a international application or convention application within 12 months. If you file a convention application, then within 12 months you can select from the convention countries, but there is another system under the Patent Corporation TT where you can file this application in national phase within 31 months from the date of filing the provisional. So you get a lot of time to file those applications in foreign countries. So I was just this how the patent impacts the life, how patent can change the life of an inventor. So this is one example I would like to show you. This lady's name is Kavita Shukla. She is a US US citizen, but her parents from India. And when she was small, she used to visit her parents in India, but always her grandmother was very much worried about her health because his father brought water from US so that it doesn't contaminate or it doesn't affect her health. So he was so much worried about her daughter. So he came to India, and then this girl observed that her grandmother making some kind of herbal extract, for drink so that she doesn't get ill. And from that she got an idea, and after going back to US when she was in 10th standard, she came to know, she studied those herbs in detail, and she found that the foods, I mean the fruits, these fruits, which is so these fruits used to perish very quickly within 2 days, 3 days, or 5 days. But then she studied those herbs and she extracted certain components of it, and she made a paper, the fresh paper. She named it as a fresh paper. And the fresh paper, when you wrap those fruits in the fresh paper, is long life, shelf life is increased. So you can keep those fruits for a month also without any fear of destroying it. So there's no fungal infection and all. So I just I will now give you the link of this, and you can just start this video because I am not able to hear from this video. Just I'm sharing. So just you can play for this is a short video just for information. Can you play this video? Hello.
So which video? That YouTube video?
Video. I'm just giving you the link on the chat.
Please give.
Yeah, I have given. Just can you play this?
Just a moment. Om, just try.
Yeah, please try.
Om, acha. The video ta kodi dekhi parni kodi achi? Where it is? Kardam sir, where is the video link?
I have shared on the chat.
Okay.
No, sir, it's not in the chat. It's not
It's
in the
not in the
chat, sir. It's not showing.
That's what
Not showing.
Meeting chat.
Meeting chat not showing, sir.
I have just posted what is there.
I think it's the same which is mentioned on the screen.
yeah, but
Yes.
you cannot open it there. That's why.
YouTube.
Yeah,
If you can click on it, I think it will also come with the sharing.
No, it is video link is not in the chat part. Tanmay is telling.
Yeah. That
It's
link
in
has
the-
to be
it's on the
copied and
screen.
put into the chat box.
Yeah.
then we can directly click on that. From the screen, it's not possible.
If it is clickable, unless
Yeah, sure, sure,
No, in
sure.
my slide it's clickable, but when I'm presenting, uploaded on this one, not clicking.
Sir, can you please copy that link and put in the chat box?
I have copied and I have.
Hey, sir, it has to be hyperlinked. Somebody has told in the group. Tanmay has told. I don't know the procedure.
No,
This is a meeting
that's
chat. Uh,
like this can be in the chat box also. You can click it. Hyperlink is a different thing.
Okay, I am not aware of.
New hyperlink. I am just sending.
Sir, you just copy the link and put in the chat box, sir.
I am just देखिए आपको आ गया क्या ये?
Yeah, I think it has come. Yes.
Just
Yeah, this can be clicked. I think please click and share in the screen.
somebody has asked me a question whether service provider company go for patenting. See, the service provider company can go for patenting, but for what? Whether only just to provide, like the many Ola, Uber, they have a lot of patents because they are using the technology, not for servicing. But when you use technology in providing the services, certainly you can get patent on it.
If there is any other question during the meanwhile, we can take up the questions. Any other questions, please?
That can be taken up by the time the video will be played. I'll see how to.
Yeah, if there is any question so far, I can take up those.
I think, sir, you can also explain regarding the early publication and early examination. We expedite the. Sir, please speak a few words on that.
Yeah, there is a process of early publication and early examination. So suppose now, since you are a suppose early you want this particular invention to be patented fast, so you can suppose you are a startup or any individual, you can make an request for early publication because the the benefit of early publication is that when somebody is copying it, infringing it, you are entitled to claim damages from the date of publication. So early is published is better. So this is one. And secondly, early examination also there is a provision. But now that provision is slightly has become obsolete in the sense that now we have come up with the expedited examination. So
Yes.
expedited examination is one where you can make a request for expedited examination, but they are available to certain kind of people, not for all. Uh, so usme like there is startup companies, MSME, when the applicant is a woman, when there is a company, government organization, or the or organization which is financed partly by the government. There is a special technology which needs to be patented faster than God to make a request to the government, and they will declare the technology for expedited examination. So there are certain provision for expedited examination.
Sir, there is one more
Fine,
question.
sir.
Mr. P.K. Pandababu, kindly reply, sir.
Okay, let me see. Panda Sahab, what are the costs involved in filing, obtaining IP patents? See, as I said, the filing fees is very, very normal. If you are a individual or startup or MSME or university, okay, the filing fees is rupees 1600 when you file a online, or if you are filing offline, so there is a 10%, 1700, something like that, 1760. So 10% more one has to pay. If there is a if there is a legal entity, then you have to pay 5 times, means 8,000 rupees.
Yes.
So this is one. What are the fee which needs to be paid? One is the filing fees, and another is the examination fees. So examination fees is 2,500 rupees. So 16 plus 2,500 is the filing fees for individual or and startup and university and MSME, and 5 times of that for the legal entity. So these are initial two fees are to be paid. Rest of the fees depends on the time. Suppose you reply your queries raised by office within 6 months, there is no additional fees. But if you want to take further time for 3 months, so every month you have to pay the extension fees. Once the patent, so by this you can get a patent. And if you are engaging some attorney to file this, then their charges are different. But when you engage IP facilitator, then you don't have to pay that fees. The government of India will pay their fees, and they will get you patent registered. If you are but this facility is available only for the startup companies. The rest of the people have to pay.
Can you go to the next slide? Let us complete, then we can have the discussion.
Sure. I is not able to open this link.
And Om, kindly help, sir. Om, say help kala sir ko.
I think
হ্যালো
Go.
ভিডিও শেয়ার করুন স্যার
yeah. Please.
I think Hanuman Chalisa could
Huh? But normally when I present this, I think it's open. So so now can someone stop this Hanuman Chalisa? Sorry. What I try to say, this girl opened by inventing this fresh paper, she made a company Fresh Glow, and by this particular, she is one of the top 5 entrepreneurs in US by this particular. So this has a huge application. This fresh paper, entire food industry is using this, and she has become millionaire. And uh, she is one Times Magazine. She occupies a lot of space. So my point to convince you that you see the problem around and open. So they are market oriented, they are commerce. As I said in the beginning, any idea, any property, any intellectual property to be used commercially. So commerce is important here. So you make a product which has huge potential. So the paper in which the packaging is done is so important, or by using our own traditional herbs, So we are not claiming any herb. She is not claiming any herb. She is claiming a paper. She has made out of that paper. And that paper is dipped in that herb product, and once it's dried, and there is a process, complete on automated process, and when this paper is made wrappable, and the fruits can be read by this paper, and it doesn't perish actually, the food. So it is so huge impact on the industry, a huge impact on the people who are using it, customers and all. So this is a kind I wanted to show you in the video, but anyway, we are not able to see. So another example, how patent impact. This is socket valve. So what has happened, in Africa, a lot of people play football. They football also, but they have not much electricity. And by when this inventor came to her hometown, and she said she saw small children are playing with the ball, socket. Then she the idea came to mind how to conserve this energy and convert into electrical energy. So she invented a device. You can see here orange color device where this device is put in this wall, and when the children playing or even man playing this football, this particular uh, this generate energy and converted into electricity. So this ball, if you use this mobile just one hour, it will be charged. And one night it can this energy is so sufficient, then you can use as a bulb for one night. I mean 12 hours you can use once it is charged. So this system, you can play with this ball, and there is a device inside which generate energy and store the energy, and through by this energy you can I mean charge your mobile, any device, or you can use as a light source. So this is one of the important innovation. How these are impacting. If another video is there, but I think the video are not able to see. And this packaging. Packaging is a big problem today. Plastic use, everyone knows what are the problem. So we have 80 million plastic bottles produced every year, and 80% plastics bottles end up in landfill. And 800 the life there it takes 800 years for biodegradable. So huge impact on industry. So if how to avoid, how to reduce the use of plastic. So one of the inventor invented a bottles made of paper. So it's a pulp blended of wheat straw, bamboos, husk, and sugarcane, etc. And then he has come up with the this kind of this thing. Like, I think somebody using now.
Sir, I think your video
Yeah.
is opening.
Yeah. Yeah.
Very good.
Very good.
The voice is not, I think, are you able to hear the voice?
No,
Not-
voice is not coming, sir.
Voice is not coming. I think replay. Voice is not there.
Hello. हाँ हाँ ଆଣିକି ଡେଲିଭରି ଦବ ଆଉ କଣ ହଁ ଫାଷ୍ଟ
This is a fresh paper. I think that so these are I was here. So the person has invented a new process of making the paper water bottle, and by blending the different kind of straws and bamboos husk, sugar cane husk and other things, and these bottles are 65% compostable material, and they are so 100% they are biodegradable and not producing any plastic material, and they are patented in India and also in US, and they have also taken the trademark also for paper water bottle. So this is how the new idea can be commercialized uh, through patents and innovation. So patent facilitate from mind to market. That is a basic idea. You do research, you apply that research and get patented, then demonstrate to the people who are interested in your idea to make it to the market, and then license them. The licensing, it can be a exclusive license to one person, it can be non-exclusive license to many people, enabling manufacturing different states. Maybe you can restrict by state, in this particular state so and so will manufacture, and so state so this will manufacture. So patent basically help you to commercialize your innovation, but and how that patent can, I mean, change your life. All patents may not be that much successful, but patents are always change your life if they are commercialized. So by licensing, you can bring the innovation to the market. And how this has to be done? There's a when once if you are interested to file patent, then disclose your invention. Either you can do it yourself, or you can appoint patent facilitator or patent attorney, and then you discuss with them, and they will conduct interview with you to know more about it, and then they will draft your patent application, then whether to patent it is patentable or not, and they will file your application. After certain queries are replied, and they will make your case more stronger, and they will file, then they will get you patent by following the process, and they will also help you in licensing of patented technology. And the patents are also maintained every year you have to pay the fees for their maintenance. So for 20 years, first 2 years are free, no fees is charged by them. You can thereafter you have to maintain it. If you don't maintain it, this will lapse. The patent will lapse, and anyone can use your patent. So very important to maintain patent to avoid any this thing. But there are patents are not absolute, right? They are not absolute. They are subject to certain conditions or certain exceptions. One is that government can use your patent without your permission, but permission can be taken later on. So the government can use it, but government no one can use free of cost. In case government use it, they will pay you some reasonable amount of royalty. Government can manufacture or can import it, or anyone can use patent for experimental purpose, research purpose, teaching purpose. Government can distribute your patented medicine.
ତାଙ୍କର ବୋଧେ ଟିକେ ନେଟ୍ ପ୍ରୋବ୍ଲେମ ହଉଛି ଡକ୍ଟର କର ସାର୍।
I think there is some network issues.
I think you can continue, sir.
Yeah. So as sir was mentioning regarding the patent filing, just I would like to inform that we are having CTDC. There is an IPFC, Intellectual Property Facilitation Center, which has been established by Government of India, Ministry of MSME, to provide such facilities services like patent filing, design filing, copyright filing, GI filing, trademark filing, to make FTO analysis with a very nominal fee or at no cost. So anybody who is having interest to file any kind of IP, please contact CTDC, IPFC. Will provide you those kind of services. We're also empaneling some of the attorneys. There are good attorneys. They will pay it. Now we are planning to empanel some good attorneys. Those who are subject experts can provide you these kind of services, and you can avail these services. And once you get the approved, if it is a micro, small, and medium enterprise, you are having Udyam registration for trademark filing, you will be getting 50% discount in fee, government fee. For physical filing, it is 10,000 rupees. You can pay 5,000 rupees. And on the approval, you will get rupees 10,000 rupees reimbursement from Government of India. Similarly, industrial design also you can get registration of 15,000 rupees. For patent, you can get reimbursement from Ministry of MSME 1 lakh rupees. For GI, it is 2 lakh rupees. This was the information. Now, Dr. Kardam sir has come.
Yeah,
Sir, please carry
sorry,
forward.
I disrupted, but I am not able to share my screen. I think host disabled this sharing the screen.
Post disabled, please. OCF kindly make enable to share the screen.
ओम टिके तको देखिला कौन प्रॉब्लम सर कर रही छी
ହେଇଗଲାଣି ହେଇଗଲାଣି।
I think your screen sharing. No. I want to, sorry. Like code like that. Sorry, eh? Oh,
Yes, sir. Yes, sir. It is visible, sir.
yeah, yeah. Sorry. Coming to the slide now. Hmm. So the patentable subject I was talking about, any article, any apparatus, machinery, or any component can any new and inventive article can be patented. Any substance, mixtures, living, non-living product, pharmaceutical, lubricants, anything is a mixture can be patented. And any process also patentable, but only thing is that it should meet the criteria of novelty, inventiveness, and industrial applicability. As I said, that what is new, I say, when I say novel, novel means it should not have been published prior to the filing of the patent application. It should not have been used prior to the filing of the patent application, or it should not have been conveyed to anyone, even orally, or or even it should not have been patented by anyone. So any prior publication, any prior public use, or any prior claiming, yani patenting, will destroy the novelty. So before publishing it in a newspaper or research paper or any putting on the internet or maybe YouTube, you must file a patent application. And once you file a patent application, you can publish it, you can communicate to, you can use it, and you can do anything after filing the patent application. So the important requirement is before doing so, you must file a patent application, otherwise novelty will be destroyed. So the combination like inventive, as I said, what inventive means should not be obvious to a person skilled in the art. It should involve important technical advancement. Just for your information, this is a this is a clip, jam clip. Are you able to see this jam clip?
Yes, sir.
So if you straighten this one, this is just a wire, just a wire. Or if you straighten it, it is useless. So what is inventive in it? What is inventive in? If somebody has given fold to this wire, तो व्हाट इज इन्वेंटिव? एक वायर ही तो है, कुछ ज्यादा तो है नहीं इसमें, तो इसमें इन्वेंटिव क्या है? So when we talk about the documentation, documentation management, suppose you want to hold papers together and there are many restrictions like in check or draft, you can't make hole like all pen, you can't use all pen. So the all pen makes a hole in the paper, and that is prohibited by for certain instruments. So this jam clip is able to hold paper together without making any hole in the document. So what is new in it? What is inventive in? The inventive part is that these two folds to the wire, the both end, they they are folded in such a way that both the ends of the wire exert the pressure against each other. ऐसे ऐसे against each other they are pushing both the ends. And by this fold, they are able to hold the paper. So this is a inventive idea. It is not obvious. So that means it involves some technical advancement compared to the existing knowledge. पहले knowledge क्या था? Earlier we used to use all pen. All pen used to tear the paper. And to avoid this problem, one has made this jam clip. Very small item, very important for the documentation management. So this is a new and innovative idea. So you don't think about the big thing. You think about the problem around you and how to solve those problems. It's a matter of patent, you know. मतलब पेटेंट के लिए कोई ऐसा जरूरी नहीं है कोई करोड़ों रुपए की आपको रिसर्च में लगाना पड़े. You look around you and find the problems and address those problems, work on those problems. Industrially applicable, I have told you. But there are certain things which are not patentable. These are the unpleasant things for an inventor. What are those? The scientific principles are not patentable. But how to use those principles in a process, they are patentable. Formulation of abstract theory is not patentable. Any living thing occurring in nature. So any thing which is occurring in nature cannot be patented. If it is genetically modified, then it becomes patentable. If you like a what do you call genetic material in our body, nucleotide or whatever. So but if you genetically modify them, people are making medicine out of it. You know, so they are not non-living, चाहे living हो, चाहे non-living हो. Those occurring in nature cannot be patented. New property. If a product is the substance is already there, but you find out a new property of it, then not patented. New use. Suppose there is paracetamol, known for analgesic property, बुखार कम करने के लिए. अगर आप if you find that it also prevent heart attack, suppose if you find that, then this is new use of a known substance, not patentable. Then any admixture, not patentable, but compositions, synergistic compositions are patentable. Mere admixtures are not patentable. Mere arrangement, rearrangement, duplication device, not patentable. Any method of agriculture, horticulture, they are not patentable. Mathematical, business method, software per se, presentation of information, integrated circuit, copyright, design, traditional knowledge, any invention relating to atomic energy, they are not patentable at all. So these are something not patentable, but their application in developing a new process or new product is patentable. So I was just, although I have already explained in a short manner, but there is a scheme now for startup companies. The scheme is known as SIPP, where the facilitator or IP Mitra are nominated to help the startup companies for filing their patent, design, and trademark application. And facilitators' fees is reimbursed by the government. 80% fee rebate to the startup and MSME is provided, and 50% fee reduction for trademark application. And this reduction of fees is not only one time. Every stage of processing, wherever this fees is, even maintenance fees is also reduced. Maintenance fees, renewal fees are also reduced to the extent of 80% and 50% for trademark. So there is a lot of advantage for them. And expedited examination is also there, and where you can apply. And many patents are by using this process of expedited examination, many patents are granted within 67 days. Many 67 to 100 days patents are granted under if you use this particular process of expedited examination. Yeah, who are entitled for expedited examination: startup companies, applicants who are selecting Indian Patent Office as a ISA and IPA for filing international application, they are entitled. So there is no difference between startup, individual, or MSME. Anyone, if there is application by MSME, they select Indian Office as a ISA, IPA for PCT, they will also be eligible for expedited examination. Where woman is an applicant is also entitled for expedited examination. Government funded institutions and bilateral cooperation between the countries, they are also entitled. There is a separate queue for expedited examination, and within, I think, within 1 month examination report is issued, and within 2 months one has to reply. So every point of time there is a fee reduction, the timeline reduction. All this is a very fast line, so patent is granted very quickly. But there is a slight fee hike for natural person 8,000 rupees, or MSME 25,000, and uh, other companies 86, more than I think 50,000. So this is very, very important. If you pay slight more fees, then you can get it examined at faster rate. Recently, it has been changed now. There are applicant is a department of Government of India. Applicant is a institution like university established by central law or state law. They are also entitled for expedited examination. And applicant is wholly, any institute wholly or substantially funded by the government is also entitled. So पहले जो list थी उसमें those with the red ink, they have also added as a applicant entitled for expedited examination. So I have come to my conclusion that intellectual property is a great asset to any enterprises or individuals or startup companies. So you generate your idea by looking around the problems around you, by thinking new solutions, apply your idea into action, convert into a process or product, and create IP through application of idea, evaluate what kind of IPR can be protected, IP can be protected from all possible instrument like patent, trademark, copyright, or maybe commercial design. Just have a look, and never publish or make public your idea or invention before filing a patent application or trademark or even design application. Then you can get it evaluate, and then you can commercialize. कीप विजिल टू प्रिवेंट इन्फ्रिंजमेंट, का कोई आपका थर्ड पार्टी कोई कॉपी तो नहीं कर रहा है. एंड रेस्पेक्ट आईपी ऑफ अदर्स, जिस तरह से डोंट कॉपी इट, डोंट डुप्लीकेट इट ऑफ somebody's IP. And then renewal, maintenance of IP. The patents are renewed every years for 20 years. Trademark once in a 10 years, but so every 10 years it is renewed. And design 10 years plus another 5 years. So before expiry of 10 years, you must renew design for another 5 years. And similarly, other IP also. So I think With this, if you have any question, I end my presentation. And if you have any question, please ask me, or you can write down any questions, any mail or to me. I will be very happy to reply.
Thank you,
Sir,
sir. Sir, there was a question initially given by Mr. Manibhushan. That while working on a patent product under
Mm-hmm.
license,
Mm-hmm.
the license finds an improvement which is patentable. Will this
Mm-hmm.
new patent belong to the licensee who has invented it, or the licensor on whose product the improvement has been made? We want to know this information.
So there are two aspects. One is if the license agreement contains a clause that whatever improvement you make on my product, my intellectual property, uh, you have to assign back to me. That means licensor. Okay. So in case there is a clause in it in a license agreement, then you have to transfer it to that person. Okay. But you can patent it in your name. Any improvement over the existing product can be patented provided it meets the requirement of novelty, inventiveness, and industrial application. But the license clause will force you to transfer those rights back to the licensor. If there is no such clause in the license agreement, then you can go for a cross licensing. Suppose he has charged you some fees for transfer of technology, then if you have made a improvement over it by developing some important features, then either you can ask for the royalty of your patent or you can get a fee reduction. You can do it anything as you wish, but you can patent it.
Thank you, sir. And there is another question from Mr. P.K. Panda.
Uh-huh.
How tough is violation of patents penalties involved? The legal
Patent.
infringement.
So if somebody is infringing it, so you have to fight the case in the court. So nowadays the courts are very prompt or very proactive in awarding the damages. So I think I will share some cases where the heavy penalties are imposed by the courts in infringing the patent rights. You must have heard in the past there's a Ross patent was copied it by one pharma company. I will not name the company here, and the court has imposed heavy penalty on it, and they have paid it. So if one does the infringement of patents, he is liable for two things: damages which has occurred and account of profit. Whatever profit he has made, he has to reimburse it, and he has to keep the accounts books, and if directed by the court, to be monitored by them. So in India there are special bench, IP bench is there. I mean, department in the High Court of Delhi, they separate IP um, division where the courts, I mean, special courts are appointed in it, and they, I mean, take judgment, or they look into those specially. And similar IP division is created now in Chennai, and I think the more such kind of division will be created in other high court also.
Yeah, thank you, sir. Sir, just to share my experience, many of the micro and small entrepreneurs,
Ji.
sometimes they may be victim of the infringement
Hmm.
because they do not know they have filed for some trademark, or they are using some trademark. Somebody gets
Hmm.
a file. Really, they
Hmm.
become are design kind of things. They are really landing into very big issues. when they
Right.
receive a 10, 12 page notice from the High Court, and they get panic because they do this. That is why it is very much important to make them aware what to do and what not to do. So IP due diligence is
Yeah,
very
so
important. They must.
due diligence is very important, and there are some kind of, the FTO searches, FTO searches. I mean, freedom to operate. So before you using bringing the product into market, or before you develop anything, you get the search conducted, a report prepared. How much freedom you have to operate? Are you going to infringe somebody's patent? Are you going to infringe some kind of trademark by this particular product? Are you going to infringe somebody's design? So before you bring the product in the market, you must get this freedom to operate search conducted and get the report on it, so that you are free from such kind of notices of infringement. Sometimes what happens, people keep the trademark similar, similar to like Sony, Sony. They will try to keep it Sony, Sony. They phonetically similar, but we should not do it. We should create our own new innovative trademark, like Apple. Apple doesn't contain any apple to eat, but that has become the global mark because of its quality, its reputation of the product. And today, people feel that, today your name may not be so important, but once you improve your quality and then of your product, it will bring the reputation, it will create your reputation of your product, then build the brand of your product, isn't it? And
Yes, sir.
maybe some unexpected name will become popular. So we have to create our brand. Don't worry that it is not, don't copy it, but create your own mark. Today it may not be popular, but once your quality is improved, your branding will certainly increase, and your trademark will also quite, may become well known in future.
So for this kind of cases, actually what we are doing, we are conducting intermittently, periodically the IPR clinic at
Right.
CTDC, where we are connected to some of the eminent people like you, those who are highly knowledgeable. We also take their help, because MSME entrepreneur or startup, when they comes with the innocence infringement kind of a
Right,
notice
right.
he receives, we give him support. Otherwise, he gets panic. Once he's connected, he has to pay in thousands. His pocket does
Right,
not
right, right.
permit. Sir, with this, I think definitely, sir, your knowledge and your guidance will be helpful. In future, we'll be
I will be
disturbing
there.
you.
Anything, please contact me for any kind of
Yes, sir.
suggestion, advice, and that too I will give you free of cost, no problem. I am always,
Yeah, thank you, sir.
yeah, yeah.
All the entrepreneurs and research scholar, youth scholars, they will be startups, they will be benefited, immensely benefited. So there is
Sure.
a request from Dr. Rajesh Sen and also Mr. Santirajan Mehra and many other participants. They are very
Uh-huh.
much excited by looking at your PowerPoint presentation, the power of PowerPoint presentation contains.
Uh-huh.
And
I
they
will
are,
share.
they are requested to share it, sir.
Sure, sure. I will. You have I think, some WhatsApp number, Odisha Development. So I will share on that.
Yes, sir. You can share so that he can communicate to share. You
Also
can share.
share with Mr. Mehra, sorry, Behra Saab. Also, he will also share to you if you don't get it. I will share on both the WhatsApp number.
Okay, thank you. If there is no other question or anybody has any kind of query, all the esteemed participants, those who are here, if you have any kind
Yeah,
of doubt,
we can also plan for another session for GI and the publication. This part which can cover also. So maybe another session we can arrange.
okay, that's fine. Because it's the beginning, the IPR is a subject, is a very vast subject. There are many things contained. Sir has tried to precisely, within a very short time, try to cover and give the inputs which are very much essential. Many times it is seen that many research scholars, very qualified people, and the MSME entrepreneurs, due to the lack of awareness, they lose their patentability right, because they are published somewhere. They are excited to publish something in YouTube or some social media, but they lose their patentability criteria and credibility. So this is a very informative news. Sir, I think as Mr. Gautam Mahanti has requested, and OCF, we can organize one more exclusive session GI, because GI is now prime focus for at the national level. In Odisha, total 27 GIs has been registered. Government of Odisha MSME department is also has been engaged as nodal agency for the GI. We can definitely conduct sometime, and we'll take the help of Kadam sir definitely. With this, any other thing? Anybody has got any other question?
Dr. Kar, I have shared
Sir.
now this my presentation in the chat box.
Okay, thank you, sir. Yes, this in
Yeah.
PDF. That's very good, sir. Instant this. Thank you, sir, for your quick response and sharing this knowledge. It immensely helpful. It is really very precious thing, sir.
Thank you so much, and for giving me this opportunity to share my thought with
Yes,
the
sir.
participants.
I think, sir, we will. If there is no other question or query, we can sum up with the concluding remarks.
Yes, sir.
Anything?
Yes, sir. Yes, sir. Please go ahead.
Okay.
Please go ahead.
So thank you. It is a great opportunity today, this by Odisha Corporate Foundation and this initiative by inviting such an eminent speaker and really an elegant, the knowledgeable person in the field of the IPR who is expert, he is an experience and worldwide. Very nicely, it is a very vast subject I mentioned, but very precisely, very informally, we are a good teacher. He has educated us. What is IP? Why IP is important? How to commercialize the IP? How to take the mind to money? An idea to the wealth. He has shown that roadmap. And also the difference between the patent, different type of IP components like patent, industrial design, trademark, copyright, GI. Sir has very nicely has explained. And he has very beautiful thing that the IPR in everyday life. Anything we are doing that there is intellectual property right, it is everywhere. It is omnipotent and omnipresent. So we cannot just ignore it. If we ignore, then we will be treated as we are uneducated, unqualified. This has become the basic level of understanding today's context. Then also, like very beautiful example, sir has already shown that pressure cooker, how the pressure cooker contains multiple IPs in it. Like patent is there, where the utility and the different linkage, its functionality, the design, trademark, and also the literature, copyright, multiple IP in one product. So that is very important, very exciting and informative example. Is sir has already mentioned that patent is a statutory right. Once you get it the right, the patent is being granted in your grant. Nobody can infringe, nobody can take it. Your innovation, your technology, it can create a lot of wealth. Either you can start with your own industry, with your own innovative ideas, or you can license it or cross license to somebody and you can make money. And it has a limited period. That patent's life period is 20 years. How to maintain the patent, what are the fees, all the things has been very nicely discussed. Why it is important and how this creates a value for the business. And any startup is coming at with an innovative idea, it must go for the patent. Many a times, as you said, sir has already mentioned, many people to consider your patentability criteria, you have to focus that you should not disclose, you should not publish, you should not bring it to the public media, you should not do it before filing. And Sarah also explained that provisional filing and the final filing. If in case you are working on an innovative idea, it may take quite a little long time to claim your patent rights, to define to validate your idea, the utility. Then you can go for the provisional patent filing, and within a period of 1 year of the time, and you can go for the final filing with your claims. Regarding fee, that the government of India has already created ecosystem. That is why India is emerging as a technologically developed country. 7 years before in Global Innovation Index, India was in 81 rank. In 23, it has come to the 40th rank. That means the all initiative at DPIIT, Ministry of MSME, Department of Science and Technology, all government department is working well. So we have coming in the 40th rank. And today, with a lot of innovation, number of patent applications also getting filed more today in comparison to others. regarding earlier there was an issue of the grant of with your patent. It was getting excessively delayed. So that is why government has taken a lot of initiatives and engaged more examiners, having the provision of early examination, early publication, expedite your course of action so that quickest possible this patent can be granted. This can be examined. Apart from this, as such IP Mitra and IP facilitation centers has been established. IP Mitras have been recognized. You can find their list, you can consult them, you can take their help. So that usually startup or micro, small, medium entrepreneurs or individual people, they are scared up because of their money. IP attorney, they charge heavy money. That is why no small and micro entrepreneur becomes very hard them to afford. So government of India already created a lot of ecosystem facilities, engaged many consultants. You can consult. You can also contact IP facilitation centers. In Odisha, there is an IP facilitator I mentioned, as I mentioned at CTTC. You can contact for any kind of help. It will be provided. So this also the patentability and what are the things which cannot be patented. Patentability and non-patentability, the kind of innovation ideas, what are the innovations which cannot be patented. These also are clearly defined. So with this, I think very fairly, it is a very good discussion, very good knowledge sharing session. And thanks a lot, sir. Also, instantly you shared the PowerPoint presentation, which was very of high demand and requested by many of the participants, including me. So we are very much grateful and thank you, sir, for sharing your knowledge and sharing your participation. In future will be definitely anybody wants any kind of help can contact OCF. I think OCF can also plan an IP facilitation or counseling cell where intermittently, periodically, we can discuss with the entrepreneurs. We can provide these kind of services because we are in a good network of many intellectual people and experts across the country. With this, I hand over to now OCF, Mr. Dilip Kumar Satpathy sir or HK Bera sir to take over it.
The Bera is not there. I'll request Usasi madam to just speak few words and conclude. Madam.
Good evening, everyone. I'm Usha Shirat, chairperson of OCF, and I'm so privileged. And the OCF fraternity, all members who have joined today, they are so fortunate, and we are so privileged that we have got today two wonderful speakers who explained about so many things clearly and nicely. And indeed, it was a wonderful awareness program on patent and trademark issues. And we are so thankful on behalf of OCF. I would like to give my thanks from the bottom of my heart to Dr. Kishan S. Kardam sir and Dr. Sachikanta Kar sir. And definitely in future, we would like to take the help of both the sirs on this particular subjects. And we entrepreneurs from Odisha are really looking forward to go ahead on these issues and prove ourselves that yes, we are also doing very good things. Thank you so much. Thank you so much. Good night, sirs. Good night, everyone.
Thank you very much, sir. Thank you, Kardam sir.
Thank you, sir. Please call me. I will be there at any time. Any help you require from my side, either I will be there. No problem.
Thank you, sir. Thank you so much, sir.
Thank you. Bye-bye.
Sir.